Welcome to Prime News Updates. Please subscribe to our channel and turn on notifications to stay ahead with the latest breaking news.
I think his request was that the court should adjourn the matter pending when they are letter to the Chief Judge of the Federal High Court to transfer the matter to another judge is attended to. Though yesterday our client issued a statement to the effect that there's an attempt to force this particular court to recuse itself for the matter to be transferred to another court, but we disbelieve them. It is not true. However, when we appeared before the court this morning, it was confirmed that that move or that information is correct because the claimant counsel informed the court of the development. But we were opposed to that because there's no basis for it. It is an attempt to frustrate the order of the Supreme Court that this matter be heard immediately and the hearing be accelerated. And that judgment endured in their favor. We don't know what they are scared of. We don't know why they are no longer interested in this matter being heard expeditiously as expected and as ordered by the Supreme Court. There's something that we are here to come to terms with. There's something that we don't know, but at the due time we shall know.
Wait, let me ask you a question. As a counsel to the ADC, they are saying that the reason why they are requesting that the CJ be assigned the case from that judge is for the matter to be heard expeditiously. And you are saying that this is not what they are trying to achieve.
No, there's clearly. I think they have never been interested in this matter being determined. What they have been looking for is another or anything that will keep the party in permanent disability. And when they got such order from the Court of Appeal, to them it became a magic wand. And to God be the glory, the Supreme Court set aside that order, and they are back to this honorable court. Rather than getting the certified copy of the judgment of the Supreme Court and furnish this court with to enable the court to comply with the order of accelerated hearing, they are here this morning asking the court to stay further proceedings pending the administrative letter to the CJA, pending the outcome of the administrative letter to the CJA. And we say no. If anything, the court should adjourn the matter sooner pending when the court is furnished with the judgment of the Supreme Court, for us to know and for the court to know the extent of what is left of that case for the court to decide. Because on the last and just date, the court adjourned this matter sooner pending the outcome of the Supreme Court judgment. So it is unfair to the court that we are asking the court to do something else today when the court has not been afforded the opportunity to see the judgment of the Supreme Court. When a case adjourned the matter pending the determination of an appeal, and the appeal has been determined, the only way the court will know that the appeal has been determined and to know the content of the outcome of the appeal is to have a certified true copy of the judgment. And the court has not been furnished to the certified true copy of the judgment. That is where we are, and the court agreed with us and adjourned the matter pending when the court is availed with the copy of the certified true copy of the Supreme Court judgment. So we are ready, we are eager, came prepared to have the matter determined as ordered by the Supreme Court. But you can see what played out. They are afraid, we don't know what they are afraid of, and they have decided to truncate today. So we are waiting for them. Anytime they are ready, we are ready. That is our position.
Representing Senator David Mark, the second defendant and national chairman of African Democratic Congress.
We saw that the claimant gave it an unusual request of saying that they've written to the chief judge that the matter should be assigned to that judge. And this was met with a series of objections from councils across several parties. What do you have to say?
Yes, because we are taken aback. We felt, given the order of the Supreme Court for accelerated hearing of this suit, the only thing that should be done today is hearing of the suit. But after coming to court, we were intimated by the claimant counsel that they have written to the chief judge for the assignment of the case, and they did not copy also the letter. They did not serve also the copy of the letter.
But they are saying that they are not mandated to serve you with copy of the letter, saying that since it has been served on
they are mandated because we are party in the proceedings. Trial is a serious business, and there must be fair hearing. Every issue that is raised concerning proceedings that parties are in must be duly informed and communicated to those parties so that each side will be heard before a decision is reached. So we felt it is just an attempt, not just as forum shopping, but as judge shopping. And it's a strength for Shuda because the communication is private. They ought to have come by way of motion if they want the courts to grant them any indulgence for reassignment. And usually it should be when you have allegation of bias, and that issue has to be authenticated by way of affidavit.
So what is the resolve of the judge now moving forward?
Well, the court, having had all the parties have told the ideal part, as always usual, with his lordship, he adjourned the matter sine die until when the certified copy of the judgment of the Supreme Court is forwarded to the court, and also after hearing from the Chief Judge reaction in respect of their letter for reassignment.
We may understand what sine die means. Nigerians at home don't understand what
Sine die means until further notice.
Thank you.
Sorry, sir. You made the application that the court should adjourn sine die, which it was granted. But don't you think that this will work indirectly against your clients going by the INEX timetable?
No, generally the application made by the first respondent in reference to sine die, usually whenever you are awaiting the termination that you have no control over. For instance, the decision of the Supreme Court, the certified true copy, you cannot say this is when you will get it, but we will expedite action to make sure that we get it at the earliest opportunity.
Okay.
And the decision of His Lordship, the siege of the High Court, is also of the Federal High Court, is not also something that you can also determine in terms of saying he will decide today or tomorrow. So since we are not certain as to the number of days it will take, the ideal thing is to adjourn sine die until further notice, because if he decides today, you can still issue hearing notice, can still be issued to parties to come back. If he decides tomorrow, it can still be issued. But if it is adjourned to a particular date, and he decides earlier than that date, the parties will still suffer because procedures will stultify. And if it is fixed at a date that is earlier than the date he will decide, you still come and there will be no headway. So that's why the best thing is to adjourn sine die. That's the proper thing to do in the circumstance. And the INEC decision, INEC has not done any decision that's adverse. Following the Supreme Court decision, INEC has re-uploaded the name of the officials of the African Democratic Congress, the national chairman, David March, and the national secretary of Rauf Arebashola, and the rest of them. So they are still there in the portal, because that is what is the effect of setting aside the order of status quo antebellum that was misconstrued by INEC.
So lastly, how would you describe the application made by Nafiu Bala for the transfer of the matter to another judge?
Well, it's a dangerous threat. It is most unfortunate, dangerous trend in judicial proceedings. You don't do that by way of letter when parties have already exchanged pleadings and the suit is ready for hearing. It amounts to foreign shopping and judge shopping, as if you are just shopping for judgment, which should not be done. And without any basis, from the last time when this matter was adjourned sine die by the judge to await the decision of the Supreme Court, to today, nothing has happened in the court to raise any allegation of any bias or any violation of procedure. And the director of the Supreme Court is specific to return back to this court. If the Supreme Court wanted the matter to be remitted to the Chief Judge, it will assess so in clear terms that this case is remitted to the Chief Judge for reassignment to another judge. But it says go back to the same court and conduct hearing, especially in the light of the fact that part of the issues that were raised before the Supreme Court was the issue of preliminary objection, challenging the jurisdiction of the Federal High Court to entertain this matter being a matter that is challenging the leadership of a political party, which is a political question. The Supreme Court says since that matter is still pending before that court and has not been heard and determined, go back to that court to hear and determine that issue.
We have just informed the Honorable Judge and the court
the outcome of the judgment of the Supreme Court. The appeal with the second defendant, David Mark, filed before the Court of Appeal was dismissed. They further appealed to the Supreme Court. The said appeal at the Supreme Court was dismissed. However, the order maintaining status quo ante bellum was set aside by the Supreme Court. So we are back to this honorable court, the trial court, in compliance with the order of the Supreme Court to continue with the hearing of this matter. However, just like you have known, there is a letter by the plaintiff asking that the matter be transferred to another judge of the Federal High Court. So, as it is now, the court is waiting for the certified copy of the judgment of the Supreme Court and the decision of the Chief Justice of the Chief Judge of the Federal High Court on whether to transfer or not the case before the trial court. Now, can you tell us why you made the application for the transfer?
The application for the transfer of the case from this court to another Federal High Court judge is that to determine this case expeditiously in compliance with the order of the Supreme Court, that this matter be given accelerated hearing.
Wait, does that mean that you have lost confidence in the Court of Justice?
No, we have not lost confidence in this court. Only that we want this matter to be tried expeditiously in accordance with the judgment of the Supreme Court. We are not alleging anything against the trial judge. Yes. Look at Musa.